Hi, everybody. We're going to wait another minute or so as people filter into the room. All right. Looks like we've got some folks in attendance now. So why don't we get going? All right. Hi, everybody, and welcome to today's webinar. Thanks for joining us here today. We're going to be talking about the Virginia Consumer Data Protection Act and what you need to know. Today, we're going to provide an overview of the newly enacted CDPA, which is a very broad privacy law that will govern how companies can collect, use, and disclose personal data relating to Virginia residents. I'm Sandy Bilas. I'm the co-chair of Saul Ewing Arnstein and Lear's Cybersecurity and Privacy Practice. I'm going to be presenting today and also acting a little bit as the moderator. Before we get really going, there's a couple of housekeeping announcements. First, if you want to submit a question today, there's a Q&A button at the bottom of your screen, and we will do our best to answer all questions that people submit during the program. At the end, we're going to have a specific amount of time reserved for questions. So if we don't answer right away, don't worry, we'll get to it. Second, I want to talk about CLE. So as you see on your screen, we've been approved for distance learning CLE credit in Delaware, Florida, Illinois, Minnesota, New Jersey, New York, and Pennsylvania, and we have an application pending in Virginia. So as a CLE provider, we must be able to verify your attendance. So at random points during this webinar, we are going to display and verbally announce 2 reporting codes that you have to record and report back to us using the CLE survey that you received in your reminder email. That survey will also automatically open at the conclusion of this webinar. Once we receive your responses, we can then process the credit and send your certificate of attendance to you through email. Be sure to respond to the CLE survey with your numeric codes within 5 days of today's program. We also have some presentation materials for everyone. Following this program, you're going to get a thank you for participating email. That's going to include a link to the presentation materials and access to a recording of today's program. And finally, small legal disclaimer, although we are lawyers, the provision and receipt of the information in this presentation is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who have been informed of the specific facts. Finally, I'd like to introduce my co-presenters. We have Patrick Romishin. Pat is counsel in the firm's cybersecurity and privacy practice and advises clients on issues involving cybersecurity and data privacy, particularly in the higher education and healthcare industries. He's counseled numerous clients on compliance with the GDPR, the European Privacy Law, and HIPAA. He also helps clients prepare for cybersecurity incidents, respond to potential breaches, and conduct related internal investigations, and provides representation in related litigation. And then we have Jillian Walton. Jillian is an associate in our cybersecurity and privacy practice and handles a variety of matters, including higher education matters, including conducting internal investigations, connected to compliance concerns, and cybersecurity matters, including business email compromises and cybersecurity risks relating to negligent performance by a service provider. So with that, let's begin. Today, we're going to be covering a few different topics. We're going to give you a little bit of background on how this law came to be, why it's here, and what sort of timing you can expect for it to become effective. We're going to talk about whether your company is covered or not by the CDPA and whether the people that you're collecting information about are covered by the CDPA. The CDPA provides a variety of rights to people in Virginia. We're going to talk about those rights. We're going to talk about the obligations that it places on companies that collect and process personal data of Virginians. We're going to talk about how it gets enforced. And we're going to talk about the compliance steps that you can begin taking now to get your company ready for when this act becomes effective. So with that, I'm going to turn it over to Pat for the next section of the program.
Everybody, and welcome. Thanks for being here today. I'm going to be giving a little bit of context and background to sort of orient us on where the Virginia Act falls within the broader scheme of privacy frameworks. If you deal with privacy regularly at all, you know there are a lot of different privacy frameworks. So we're going to talk about some of the principles and the way the Virginia Act, later we'll talk about how the Virginia Act relates to some of these principles. But this part is just to kind of orient us on the buildup to this act and what other states are likely going to be putting in place in the future as well. So if you've been eating, sleeping, and breathing data privacy laws for a long time, this might be a little bit of a review, but we'll try to get through it quick. So the first thing I want to talk about is the distinction between data privacy and cybersecurity. People who are outside the field oftentimes just kind of lump them together. And security is a component of the overall data privacy considerations and principles, but security is not it. One good way to think about this we found is that if you think about the Facebook and Cambridge Analytica civil penalty that was issued by the FTC, that was a $5 billion civil penalty. And that didn't happen because there was a hack or an intruder who got access to data. It happened because of a variance between what Facebook was doing with consumer data and what its privacy policies said. So there are a lot of examples like that are privacy issues, not just security issues. It's just a way of orienting thinking beyond, look out for a hacker and think more broadly about how are we handling data? What are we telling the people whose data we have? And in line with that, we want to talk a little bit about privacy principles. As I just mentioned, there are a lot of specific laws, and many businesses are subject to multiple laws at the same time. So it makes sense to talk about principles because sometimes the laws overlap, sometimes they might be inconsistent. And if you're going to look at privacy in a holistic way, if you're responsible for either creating or maintaining an entire privacy program, then trying to keep up with each specific statutory framework or regulatory framework can be a little bit like whack-a-mole. And it's helpful to orient your thinking and your decision-making by going back to privacy principles. And there are different formulations of general privacy principles. One of the more common ones is the National Institute of Standards and Technology, and they refer to them as Fair Information Practice Principles, or FIPS. And if you haven't already caught on, you're gonna be getting a lot of anagrams today. So have your alphabet chart ready. But this is, and they're formulated in slightly different ways, but they're a series of common principles that underlie many of the privacy frameworks that businesses are subject to now, and that states are taking a harder look at, and possibly the federal government is going to be taking a harder look at. In each of the frameworks, they get manifested a little bit differently, and certain frameworks prioritize some principles over others. But these principles are important to orient your thinking as you work your way through sometimes what can be a little bit of a puzzle of how to comply with multiple different privacy frameworks at the same time. So I'm just going to say a couple words about each of the principles here. So the first principle at the top is lawfulness and transparency. And obviously that it's self-evident that manifests itself in, for example, a statutory scheme like the CDPA itself, or other statutory schemes we're familiar with, like the California Consumer Privacy Act, the CCPA. But it can also be manifested in self-governing organizations like the Network Advertising Initiative or the Digital Advertising Alliance. Those are organizations that companies can join, and they agree to abide by certain principles. So it's not necessarily statutory law, but the idea is that there's a framework to which you're agreeing or you are bound to comply. And there's also a way it plays out in terms of the European Union GDPR. That framework specifically requires that companies designate a lawful purpose for processing data. The next one is purpose limitation. The basic idea there is don't use data for purposes other than which you collected it for. So if you're collecting my health data to provide health services to me, if you don't tell me anything else and don't make any further disclosures, the idea is not to use my health data to sell me products related to my health conditions. That's the general way to think about it. And a related concept is data minimization. The thing to think about there is don't collect more data than you need to collect to provide a service or make your business work or whatever the case may be, provide health services, for example. Accuracy is the next principle. And this is a recognition that the processing of people's personal data can have real world impacts. If you think about something like a credit report, that can really change somebody's life if they have inaccurate information in a credit report. So that manifests itself in rights, like a right that exists in the CDPA that we'll talk about, a right to request the correction of your personal data by somebody who's processing it. And that's similar under CCPA and GDPR as well. Storage limitation is the general principle that you shouldn't store data indefinitely and you shouldn't forget what data you have. It's best to have practice and policies, and there are some legal requirements in terms of how long data can be stored and when it shall be destroyed. But the idea is not to keep data indiscriminately, because the longer data is in possession, the greater risk there is of either security breaches or misuse. Integrity and confidentiality. Now, this is where the security question comes in. If the data is not kept secure, then you can't really have control over it, and we can't ensure that the other principles are being followed. And accountability and auditing. Accountability takes the form of enforcement. And as we'll talk about later, one of the big questions in enforcement is whether there's going to be a private right of action or whether a particular framework is going to be self-regulated or enforced by the government. The next thing I want to talk about is what some of the sources of privacy obligations are. There are one of the big distinctions between different privacy frameworks is whether you have a general framework versus a sectoral framework. And the easiest way to think about it is that the GDPR is a general framework. It applies to almost all data in the European Union unless it's being processed by a government actor. But the United States, generally speaking, has a sectoral framework. We have some of the laws that are on this screen here, like HIPAA, which applies to health data, FERPA, which applies to student data in the higher education context and other contexts, and GLBA, which applies to financial data, and FICRA, which applies to credit reporting data. So each one of those is a framework unto itself, but there's not one overarching data privacy scheme within the United States. And as I just mentioned, international law, like the GDPR, can create obligations for entities that aren't even located in the EU. The EU does have some authority to stop processing, and it's kind of an open question how fines would play out against an extra EU entity, but they can stop processing that's occurring within the EU. So there is at least some enforcement power there. And the LGPD is Brazil's analog to the EU, but there are probably going to be more similar style regulations coming online from other countries too. The next source of privacy obligations is state breach laws. All 50 states have a data breach law in place that specifies when, if a breach occurs, the victim of the breach has to provide notification to either the government or the individuals who have been affected by the breach. And each law is slightly different, so it's a real patchwork, but there is a general sense that when a breach occurs, there are situations in which it needs to be reported to the people whose data has been affected. The next category of privacy obligations come from state employee privacy and consumer protection laws. Some states have specifically mandated what employers can do with data relating to their employees. And every state has some variation on a consumer protection law that basically says businesses can't misrepresent or deceive consumers. So if a business is doing one thing with personal data, but it's not disclosing that in its privacy policies, or it's disclosing something entirely different, then that might be a basis for a civil action or an enforcement action under a consumer protection law. So that brings us to what has been a new trend over the past couple of years, and this is where the Virginia Act is going to come in, which is state general privacy laws. The first one on the scene was the California Consumer Privacy Act. And there were a series of amendments passed last year that are known as the California Privacy Rights Act. They apply more broadly than the sectoral frameworks like FERPA and HIPAA, but they also carve out data that is subject to those frameworks. So it can get a little complicated, but they are a little bit more broad. And the CCPA itself was enacted in 2018. The amendments took place last year. And the amendments that we call CPRA are going to be effective on January 1st of 2023. Another example, but hardly the only other example, is the Nevada Internet Privacy Act, which doesn't go as far as the California Consumer Privacy Act, but does create limited opt-out rights for consumers to opt out of the sale and sharing of their data. And that was enacted in 2019. But if you keep an eye on privacy news, there are lots of states that are considering legislation that's more in the vein of CCPA than sectoral frameworks. And one of the examples of this framework is the new law that Virginia just passed. So I'm going to hand it off to Jillian to start talking about the Virginia law specifically, which is the newest of these state general privacy laws.
Thanks so much, Pat. So today we're going to provide an overview of CDPA. And while we might not get in depth on every issue you want to know about, we hope to help you issue spot and plan for CDPA. All right, so let's first begin with the Virginia legislative process. You may be thinking CDPA came out of nowhere, and you would be right. Some other states, such as Washington, have been considering broad privacy laws for years without getting them passed. So what happened in Virginia? It took about 3 weeks for the bill to get through the state legislature, and it was signed into law by the governor on March 2nd. And this is largely because Virginia has a trifecta of blue in the legislature and the governor, and there was broad agreement. Virginia also has an unusually brief and rapid legislative session. So CDPA goes into effect on January 1st, 2023, which provides ample time for organizations to assess whether the law applies and then the necessary steps to get into compliance. But just because it appears as though we have a lot of time, that doesn't mean organizations shouldn't start now. So first we'll begin with the scope in terms of what data is in scope and who must comply with the statute. So to begin, what data is protected? In CDPA, personal data is defined broadly as information that is linked or reasonably linkable to an identified or an identifiable natural person. So unlike CCPA, CDPA contains entity-based and data-based exclusions. And the entity-based exclusions here are new, where CDPA does not apply to governmental entities, nonprofits, higher education institutions, covered entities and business associates under HIPAA, financial institutions subject to the Gramm-Leach-Bliley Act. But it also excludes specific types of data, so data that's already protected or regulated by HIPAA, FERPA, or FCRA. And then also it doesn't apply to data that's being processed as part of the employment relationship. So you'll notice that CDPA follows the GDPR framework, the controller processor framework and terminology. So what is a controller under CDPA? Controllers are legal persons that determine the purpose and means of processing personal data, again, very similar to GDPR. But more specifically, they're defined as for-profit businesses that conduct business in Virginia or produce products and services that are targeted to residents of Virginia. And either they control or process data for at least 100,000 Virginia residents or process personal data of at least 25,000 Virginia residents and derive 50% of their gross revenue from the sale of personal data. And so this is similar to CCPA, except that sale is much more narrow, and it's the more traditional definition of what a sale is. Here it's the exchange of personal data for monetary consideration. You might be familiar with CCPA, where it's more broad and it's defined as the exchange for any valuable consideration. One thing you may notice is that, unlike CCPA, the California data privacy law, there's no revenue amount threshold for businesses to fall within the scope of the Virginia law. So it applies to businesses both large and small. And then you'll see that, notice that the processor is very similarly defined under GDPR. It's just businesses and organizations that process data on behalf of a controller. So your typical service providers or vendors. And now I will turn it over to Sandy to talk about the new rights for Virginia consumers.
All right, thanks, Jillian. And let me just make sure I have control of the remote. All right. So first of all, just a reminder or a quick description of who is a consumer here. So the CDPA provides rights to consumers to control their personal data when it's in the hands of controllers or processors that are subject to the CDPA. A consumer is a person who resides in Virginia and is acting in their individual or household context, not a person acting in a commercial or employment context. So these rights don't go to your employees, job applicants, people who you do business with, like B2B contacts. This is just people who are acting in a individual or household context. And what are the rights? There's a variety of them provided by the CDPA. I'm going to start at the top of the wheel and go around. The first right is the right of access, which is simply a consumer can ask a controller to confirm whether or not the controller is processing that person's personal data and ask for access to that data. It's as simple as that. They can also ask for their personal data to be deleted. And it's both data that the controller has obtained directly from the consumer themselves, but also data relating to a consumer that they obtained from some other source, which is a little bit different than the CCPA's right to deletion, which only applies to data that you obtain directly from the consumer. Consumers also have a right to correction, which is the right to request that inaccuracies in their personal data be corrected, taking into account the nature of the data and the purposes of the processing. They can ask for copies, which is like the P in HIPAA portability. Just like under HIPAA, you can get a copy of your personal data and again, it has to be data that you provided to the controller. The controller has to give it to you in a portable format. And if it's being processed by automated means, they have to give it to you in a readily usable format that allows you to transmit it to another controller without hindrance. The opt-out right gets a little tricky. I'm going to discuss that in more depth in the next slide. So I'm going to move on to the appeals right. Unlike this CCPA or the GDPR, the CDPA gives consumers the right to appeal denials of requests that are made by controllers. So when a consumer makes a request and the controller says, no, we're not granting that request, they also have to provide the consumer with the ability to appeal that determination. So the way the procedures work under the CDPA is when a consumer makes a request to exercise any of these rights, the controller has to respond without undue delay and within 45 days of receiving that request. They can get one additional 40-day extension if they provide a reason for the extension to the consumer. If a controller declines the request, you have to tell the consumer why and how to appeal. And then if the consumer appeals, within 60 days of receiving that appeal, the controller has to provide a written explanation and determination of the appeal. And again, if the appeal is denied, you move on to the last step in that wheel there. The controller is obligated to give the consumer some mechanism, whether online or some other method, through which the consumer can directly contact the Virginia Attorney General to submit a complaint. All All right. There are exceptions or exemptions to these rights. You don't have to grant these rights in all circumstances. First of all, you have to make sure you're dealing with someone who is who they say they are. You have to be able to authenticate who they are. But even if they are authenticated, you can still deny their request if all of the following conditions are met. One is if you're not reasonably capable of associating the request with someone's personal data, or if it would be unreasonably burdensome to do so. Two, if you don't use the personal data to recognize or respond to a specific consumer who is the subject of the data, or associate the personal data with other data about that same specific person. Three, and you don't sell the personal data to any third party or otherwise voluntarily disclose that personal data to any third party other than a processor. If you meet any of those three conditions, you can still deny a request. Also, keep in mind that all of these rights requests are subject to the entity-based and data-based exclusions that we discussed earlier in this program, but also there are some additional limitations that apply across the board to all of the rights and obligations under the CDPA that Pat's going to be covering later in the program. And finally, I want to note that these rights don't apply to pseudonymous data, where you've disassociated the identity of the person from the data that relates to that person, and you're keeping those two pieces of information separate and subject to control so that you can't access the information and re-identify people easily. All right, and let's go on to the next slide. Let's talk about, that opt-out right. So as I said, this one's a little bit more complex than some of the other rights. The CDPA gives consumers the right to opt out of a controller's processing of their personal data for certain purposes. You can opt out if the controller wants to use your personal data for targeted advertising, which is, at least under the CDPA, is defined as displaying ads to a consumer where the ad is selected based on personal data obtained from that consumer's activities, both over time and across non-affiliated websites or apps, so that you're predicting their preferences or interests. Targeted advertising does not include ads that are based on activities within your own websites or apps, if you're not affiliating across websites or apps. It also does not include ads that are based on the context of a consumer's current search query or current visit to a website or app. Targeted advertising does not include ads that are directed to a consumer in response to the consumer's request for information or feedback. And finally, targeted ads don't include when you're processing personal data solely for measuring or reporting ad performance, reach, or frequency. So they can't opt out of those things. They can opt out of targeted advertising as I defined it. They can also opt out of the sale of their personal data. As Jillian mentioned earlier, here sale is defined a little bit more in a limited way than it is in California. You have to have the exchange of personal data for monetary consideration by the controller to a third party. It specifically does not include the disclosure of personal data to a processor, a service provider that provides, that's for the purpose of providing a product or service, that processes the personal data on behalf of the controller. It also does not include the disclosure of personal data to a third party, setting aside a processor, but any third party when the disclosure is for the purposes of providing a product or service that has been requested by the consumer. A sale also does not apply when you've got a disclosure or a transfer of personal data to an affiliate of your company, of the controller. And it doesn't apply when the disclosure of the information has been made by the consumer, where they have intentionally made available to the general public information via a channel of mass media, and they did not restrict that disclosure to a specific audience. So if you grab someone's information through a tweet, you can use that information even though it might otherwise be covered by the CDPA, and you can sell that information without it being called a sale. And finally, a sale is not the disclosure or transfer of personal data to a third party as an asset in the context of a merger or an acquisition or a bankruptcy or some other transaction in which a third party assumes control of all or part of the controller's assets. So again, a third party here is a person or entity other than the consumer, the controller, a processor, or an affiliate of the processor or controller. That's when you're dealing with a third party. So there are some additional obligations created by the CDPA in addition to all those rights that are given to consumers. Controllers that fall within the scope of the CDPA have to meet certain obligations. And you'll see that these obligations line up pretty neatly with those privacy principles that Pat showed earlier on that colorful color wheel. And again, just as Jillian described, a controller, just to remind you, is the entity that determines the purposes and means of processing personal data, and that falls within the scope of the CDPA, all those requirements, right? So what do controllers have to do? Well, they've got to meet a transparency principle, or requirement, I should say, mainly through providing a privacy notice, also called a privacy policy online. The privacy notice has to include the categories of personal data that you're processing, the purpose for processing that personal data, how consumers can exercise their rights under the CDPA, including how they appeal, the categories of personal data that they share with third parties, that you share with third parties, I should say, and the categories of third parties, if any, with whom you share personal data. Also, if you sell personal data to third parties, or if you process personal data for targeted advertising, you have to clearly and conspicuously disclose that and the manner to opt out of that processing. There's also a purpose limitation / data minimization requirement smushed together. Controllers must limit the collection of personal data to what is adequate, relevant, and reasonably necessary in relation to the purposes for which such data is processed, as disclosed to the consumer. So if you tell the consumer you're collecting their information for a specific purpose, you then have to limit your collection and use to what's adequate, relevant, and reasonably necessary to meet that purpose. You can't go on and use it for other purposes or collect additional unnecessary data. There's also a confidentiality and integrity requirement. That's the security requirement. It's fairly generic. It just requires controllers to establish, implement, and maintain reasonable administrative, technical, and physical data security practices to protect the confidentiality, integrity, and accessibility of personal data. And those practices have to be appropriate, whatever that means, to the volume and nature of the personal data at issue. So it's a fairly vague requirement. I would expect that over time, through court decisions and possibly recommendations and best practices, those sorts of reasonable and appropriate languages, that'll be filled in through that. There's some additional obligations on controllers that the CDPA has created. One is something that didn't show up in the original CCPA, but has been added through the CPRA, the recent amendments to California's law. If you want to collect and process sensitive data, you have to get consent from the individual to whom that data relates. So sensitive data can include a person's racial or ethnic origin, religious beliefs, mental or physical health diagnosis, sexual orientation, citizenship or immigration status, biometric and geolocation data is also sensitive. It also applies to data collected from a known child. Someone who's under 13 is going to be considered sensitive data, and there you have to get consent from their parent or guardian. What is consent? It has to be a clear affirmative act signifying a consumer's freely given, specific, informed, and unambiguous agreement to process personal data relating to the consumer. It can be written and electronic if you want, or any other unambiguous affirmative action. So if someone's calling you, for instance, and you're recording the call, you're going to collect information about someone, you can get them to say, yes, I consent. But it's got to be an unambiguous affirmative action by the consumer to opt in. The CDPA also has a data protection assessment requirement. So whenever you're going to be doing certain processing activities, you have to conduct and document a data protection assessment. If you're going to be processing consumer personal data for targeted advertising, or to sell that personal information, or if you're going to be engaging in profiling, where such profiling presents certain risks to the consumer, if you're going to be processing sensitive data, just like I described in the bullet points above, or any activities involving personal data that present a heightened risk of harm to consumers. The law does not define what it means to present a heightened risk of harm to consumers, but if you're going to be doing data processing that involves that kind of risk, you have to conduct and record a data protection assessment. So what is that kind of assessment? Well, you have to identify and weigh the benefits that may flow from the processing to you, the controller, to the consumer, to any other stakeholders, and to the public. And you weigh those benefits against the potential risks to the rights of the consumer. And you can also look at how your safeguards may mitigate those risks. And once you've done that identifying and weighing process, you can then basically decide whether or not you're going to go forward with that assessment. You have to record those assessments, and the Attorney General can request that you disclose them if they're conducting an investigation. So make sure you're doing this procedure if you're engaging in any of the activities that I mentioned. As we said earlier, this also creates obligations for processors, which again are service providers or entities that are processing personal data on behalf of a controller. What do they have to do? Well, they've got to assist controllers. So they have to adhere to the instructions of a controller when it comes to processing that personal data. And they have to help that controller meet its own obligations under the CDPA. So it measures to fulfill the obligation of the controller to respond to consumer rights requests, obligations including relating to the security of processing of personal data and issuing breach notifications under Virginia's breach notification law, and providing information to the controller to enable the controller to conduct and document data protection assessments. In addition to providing assistance to controllers, processors are also required by the CDPA to enter into contracts that include instructions on how they're going to process their data, that must describe the nature and purpose of the processing, the type of data subject to the processing, the duration of the processing, and the rights and obligations of both the controller and the processor in that relationship. The processor must obligate themselves through this contract to ensure that each person that works for them and that processes personal data for them is subject to a duty of confidentiality. They have to agree to delete or return all personal data when the service that they're providing to the controller ends. And they have to make information available to the controller to demonstrate their own compliance with the CDPA. Finally, they also have to cooperate with audits. And whenever they hire a sub-processor, a subcontractor, they've got to put all these requirements into the contract with the subcontractor. And so now I will hand it off to, I believe, Pat to take us through our next section.
Thanks, Sandy. I'm just going to get the control here. All right. So Sandy just went through a lot of the obligations. And one thing, our CLE code, the digits you need to know are 49432. I'll say that again, 49432.
Did I blow right by the code when I was supposed to give it? Is that what happened? I apologize for that.
Yeah, that was the first one.
All right, sorry about that, everyone.
I think there's going to be another one coming up soon.
All right.
All right, so Sandy talked about all the obligations, but there are some limitations. There are a lot of limitations built into the statutory framework as well. So, just to talk about in terms of structure, if you are familiar with the GDPR and to some extent the CCPA, a good example is the GDPR's right to be forgotten, the right to have somebody delete the data they have on you. That's something that generated a lot of press when the GDPR came out. But if you look at the way the GDPR is written, it basically says someone has the right to be forgotten, but subject to this qualification, this qualification, this qualification, this exception, and it's all written there right in the right. The way, for the most part, the Virginia statute works is that it sets forth all these rights and it sets forth all these obligations, And then at the end, there's this catch-all section that just lists all these limitations. So each set of limitations is not quite as tailored to the requirements and obligations. So it's just a little bit of a different structure if you are used to working with these statutory frameworks. And especially if you're reading the statute, if you just read the right to delete, it looks like it's a completely unlimited right to delete unless you go towards, page 8 and look at all the limitations that are in a different part of the statute. So be on the lookout for that. But the substantive limitations are that nothing in the CDPA, whether it's an obligation, whether it's a right you have to respect on behalf of a consumer, shall limit or shall not restrict a controller or processor's ability to do these following things. The first one is establish or defend against legal claims and comply with legal obligations, which includes civil subpoenas and criminal investigations. So investigations can be a little broad, and civil subpoenas, that they can come out pretty commonly. So you can't use the CDPA as an excuse not to comply with a process like that. The other one is to fulfill a contract or request with the consumer, him or herself. So if you need to process the data to, ship somebody the product they just ordered, even if they give you their data and then immediately try to opt out, if you have an agreement to send them the thing and they still want the thing, you have to be able to process their data for that purpose. The next one is a more internal facing one, but if the processing of the data is necessary to prevent, detect, or respond to cybersecurity incidents, then the consumer can't restrict the controller's ability to process the data for that purpose. And by a similar token, if the controller is conducting internal research to develop, improve, or repair products, services, or technology, then the consumer can't opt out of or restrict the controller's ability to conduct that processing. And that one's a little bit interesting because that seems like it's drafted a little bit broadly. And if you're saying that you're analyzing people's buying patterns in order to improve your products, we want to have things that sell better because people like things that work better. That seems like it's a potential justification for not allowing a consumer to opt out of that type of processing. And, we'll talk in a minute about how some of this is a little ambiguous and, there are going to be regulations, there are going to be decisions as the years go on, but that one seems like it's going to get a decent amount of action. The next one is to perform internal operations that are reasonably aligned with the expectations of the consumer. So this gets to a little bit more of a mushier determination, which goes back to those principles, the general principles I discussed at the beginning. What are the internal operations that are reasonably aligned with the expectations of the consumer? If I click on something and buy a product, then sure, I expect that somebody's going to need my address because they're going to have to ship it to me. They're going to have to be able to see my payment info because they're going to have to process the payment for the product. But if they're going to be putting my data through a bunch of automated processing to figure out what I might want to buy next, it's more questionable at least, whether that's reasonably aligned with my expectations. And the last are to preserve evidentiary privileges or exercise First Amendment rights. And those are, you would sort of expect those to be the case. The CDPA isn't going to limit those rights. And then the next topic to consider is enforcement and guidance under the statute. So when it comes to enforcement of these privacy frameworks, one of the big questions that always comes up is whether there's going to be a private right of action. So under the GDPR, there is a private right of action. And under the CCPA, there's a limited private right of action for unauthorized access to data. And under the Virginia statute, there is no private right of action. So people who are generally more aligned with businesses' interests, like the Chamber of Commerce and whatnot, that's sort of seen as a victory for them because the private right of action can generally be a little bit of a nuisance. And we've seen that play out in California because there's a limited private right of action in California, but we've already seen a number of suits where plaintiffs' attorneys have sued for alleged violations of the CCPA that are far broader than what the statutory private right of action sets forth. So the existence of a private right of action in a statute can lead to a lot of lawsuits, and the business interests are generally glad with the CDPA that there's no private right of action here. it will be enforced exclusively by the Attorney General, and violations are subject to a civil penalty of up to $7,500 per violation. We don't currently have guidance or a sense as to what will count as a violation. Is it each individual whose data has been improperly used, or is it each piece of data? We don't know that for sure yet. One of the unique things about, or maybe not unique, but one of the distinctive things about the Virginia statute, though, is that if the Attorney General is going to pursue an enforcement action and try to get a civil penalty, the CDPA requires that the Attorney General give the violator 30 days notice and an opportunity to cure the violation before initiating the action. So that seems to give a decent amount of breathing room in these instances where there's a little bit of ambiguity in the statute. It seems like the Attorney General will then have to say, I think this is a violation, you have 30 days to cure it. So at least a business will get 30 days to try to cure. Now, if you think about it, there are some violations that probably can't be cured. If somebody has inadequate security in place and data gets breached, you can't unbreach the data. So that, that's not always going to be possible. And in terms of guidance, if you're familiar with the CCPA, you know that the Attorney General has issued several rounds of draft guidance and issued final guidance over the summer. And there was a lot of public comment and a lot of input and responses from the Attorney General's office to that public comment. So that gives a decent sense as to where the Attorney General's thinking is on a lot of the, somewhat ambiguous or unclear provisions of the CCPA. And I'll tell you, the CDPA, the Virginia Act, is significantly shorter than the CCPA. It addresses things with a smaller degree of specificity. And it just, by its nature, leaves things a little bit less clearly defined. And there's not, as far as we know yet, going to be that regulatory back and forth that there was under the CCPA. But what the statute does do is it creates a work group. And their charge is going to be to submit findings, best practices, and recommendations regarding the implementation of the Act to the legislature by November 1st of this year. So well before the statute is scheduled to go into effect. So there will be some time to digest these recommendations and possibly amend the Act. But once this work group submits its findings, then the ball's back in the court of the legislature again. And obviously, everybody's going to be watching it closely to see whether and how the CDPA is going to be substantively changed through this process. So we talked about the law. So now, how do you deal with the law? And I'm going to hand that off to Jillian.
Great, thank you, Pat. So the big question is, if you're CCPA compliant, is that enough for CDPA? And the short answer is, unfortunately, no. While CCPA compliance is a great start towards compliance with the new Virginia data privacy law, there are differences that will require your organizations to take a couple extra steps. And this is, particularly in regard to the processing of sensitive personal information, the opt-out rights, and the need to perform what Sandy discussed above are the data protection assessments. All right. So to contrast the Virginia law with CCPA as the guidepost, what are some of the key differences? So to begin, the opt-out rights, as Sandy discussed, both CCPA and CDPA contain the opt-out right so that consumers can opt out of the sale of personal data, but CDPA also allows the opt-out rights for certain profiling activities and targeted advertising. CDPA's provisions on sensitive data and consent are significantly broader and more restrictive than CCPA, even though CCPA was recently amended and that will go into effect on the same date. CDPA, which will allow Californians the right to opt out of sharing their sensitive data. But this will require organizations to update their internal policies to address how will they handle those opt-out rights, and then make sure the internal procedures are in place to ensure that those rights are honored. As Sandy also noted above, CDPA provides consumers the right to appeal decisions of the controller. And this is above and beyond what's required under CCPA. So again, organizations will have to account for how to deal with this new right. All right. And then in terms of, Sandy had also discussed the data protection assessments and the general requirement for controllers to implement administrative, technical, physical data security safeguards. At this point, there's minimal guidance on what these safeguards are, but we anticipate that best practices and more information is forthcoming on this. With respect to the data protection assessments, Sandy had discussed that again, the controllers are required to conduct these where they're processing personal data for targeted advertising or profiling, the sale of personal data, the processing of sensitive personal data, or any personal processing activity, that involve personal data that presents a heightened risk of harm to the consumers. So this is currently not required by CCPA, but it's somewhat similar to the requirement under GDPR for data protection impact assessments. And your organization should be prepared to create, an internal template on that. And Sandy will discuss more of what these specific compliance steps will look like in order to prepare your organization for CDPA.
Jillian, do you want to give CLE code 2?
Oh, I'm sorry, I didn't see that. Yes, the CLE code 2 is 32593. Again, that's 32593. Thank you, Sandy.
All right. Thanks, Jillian. I wanted to quickly, we only have a few minutes left, talk about what sort of work product you're going to create to comply with this law. Hopefully, over the course of today's program, you've kind of picked up on the different things that you need to do. But just to lay it all out here, you're going to want to figure out whether this law applies to you, right? And if so, whether you collect data that is covered by this law, right? So you go through an assessment process at the outset, a mapping process essentially, to determine what data you've got and whether it applies to that data. You're going to want to think through privacy notices that are required by this law. It's likely that you already have privacy notices that you're giving to data subjects, but you want to take a look at them and make sure that they include the things that this law requires, including specifically calling out how people can exercise their rights that the CDPA provides. You want to think about internal procedures that will make sure that your company is complying with the different requirements of this law. So how are you going to respond to consumers when they make a request to exercise one of their rights? How are you going to make sure that if someone opts out of certain processing of their data, that you honor that opt-out and that you don't have people on the business teams running off and doing whatever they want with the data? How are you going to make sure that you're conducting data protection assessments at the right time, right? And what is your data protection assessment going to look like? Maybe you're going to create a procedure that sets out a form assessment so that you have a standardized way of doing that whenever it's required. You're also going to want to look at your contracts with your service providers, your processors, and make sure that they contain the required provisions. Or if your company is a processor and it's providing services to companies that are covered by this law, you want to make sure you have the same requirement. You've got to get those provisions into your contracts. And then over time, as your companies change, as you start providing new services, new products to people, or maybe moving into new areas, maybe you're opening up an office in Virginia, or maybe you're now doing business there when you weren't before, you want to make sure you're capturing those changes and complying as your company changes over time. Those are the essential compliance steps. Obviously, it's easy to reel off in a couple of minutes. They all take a lot of work, but at a high level, this should give you an understanding of the things that your company should be doing to comply. And now I want to make sure that we have some time for questions. We've gotten a couple of questions submitted. The first one I'm going to throw to Pat.
Sure.
Someone asked if covered entities, HIPAA covered entities, are required to conduct data protection assessments when processing sensitive data under the CCPA.
Well, the good news for covered entities under HIPAA for CDPA purposes is that covered entity is not subject to CDPA, and the CDPA is drafted in such a way to exclude the covered entity as an entity from being required to comply with the CDPA. So that's, I mean, it's good for HIPAA covered entities that's written in that way, because under the CCPA, the analysis is a little bit more complicated, because if a covered entity is collecting data that's subject to HIPAA, as well as data that's not subject to HIPAA, in order for all of its data to not be subject to CCPA, it has to treat all of the data in accordance with all of the HIPAA security principles. And under CDPA, there's not that kind of multi-step analysis. The CDPA just basically says, if you're a covered entity, this law does not apply to you. So it really gives you some clarity in that regard.
Thanks, Pat. Another person asked whether or not this law allows for key TAM actions. For those of you who aren't familiar with it, a key TAM action is when a private citizen sort of steps into the shoes of the government to try to enforce a law. Various laws, both state and federal, allow for key TAM actions, such as the False Claims Act, the Federal False Claims Act. The CDPA does not have a key TAM provision. So private citizens, in addition to not having the ability to sue directly for violations, they cannot sue on behalf of the Virginia government. Only the Attorney General can bring enforcement actions under the CDPA. Now, that doesn't stop private citizens from bringing actions based on negligence or fraud or breach of contract type claims. If you've made a statement in your privacy notice that is inaccurate, for instance, you say one thing about how you're collecting and using data, but you actually are doing something else with it, well, someone might claim that you've committed fraud or that you've breached a contract with them, right? If you don't adequately protect your data, yes, the CDPA has security requirements, but also there's going to be a negligence standard that courts apply to that kind of if you have a breach, for instance. So although people cannot bring direct claims under the CDPA, they can certainly look at your compliance as a guide for if you're violating a provision of the CDPA, they may be able to bring some common law cause of action.
Sandy, I think one thing to talk about in the 2 minutes we have remaining is the kind of decision process that businesses that are subject to CDPA and possibly other frameworks are going to have to go through here. And it was a similar one when GDPR and CCPA came out. And I mean, it's a question of, are you going to try to distinguish Virginia residents from other consumers? Or are you going to try to just treat everybody in a way that would satisfy the CDPA? And I mean, I think the answer is going to be different for every business, but I think that's one of the key questions to ask. That's a real significant fork in the road. And, you know, like I said, it's similar to other privacy frameworks, but for businesses that are going to be subject to possibly CDPA, CCPA, as well as sectoral frameworks like maybe, well, I mean, it wouldn't be HIPAA and CDPA for the reason I just discussed, but possibly other frameworks as well. You know, there's kind of needs to be a decision-making process at the outset. And I think that's sort of part of the mapping you were talking about in terms of the compliance steps.
Yep. All right. Thanks, Pat. Thanks, Jillian. And thanks to our folks in our marketing department, Chris and Mary, for helping us present this webinar. And I want to thank all of you for attending today. That's going to be the conclusion of our webinar. As a reminder, if you're seeking CLE credit, make sure that you fill out the survey and submit it to get verified so that you can get your certificate of attendance. And also keep an eye out for the email that has links to the webinar presentation materials and the recording. Thanks, everybody, and have a good night.